The last of the three major areas is negligence law. And the question is this: are you putting another person at risk of physical harm? The big case in this area started, would you believe, in Columbia, Missouri, down on Broadway. This woman, Sandra Hyde, was walking down Broadway after midnight on an August night. She was by herself when a red-headed assailant, red mustache, red beard, red car, pulled alongside her, leveled a sawed-off shotgun at her and said, "Get in my car or I'll blow your brains out." Well, she got in. Bottom line, she got back to the disco where she had been. She escaped from the guy. He didn't know who she was. He didn't know where she lived until he read it. The next day in the Columbia Daily Tribune, there was her name and her address. The newspaper reporter had gotten it from the police department and had used it. Now, the city of Columbia and the newspaper, when sued, said it was a public record. We can use it. But bottom line, here's what Missouri's appellate court said. And by the way, the Supreme Court of the United States let this decision stand. It is negligence if you put somebody at a foreseeable risk of harm. It was foreseeable that if this assailant got her name and address, that he would start stalking her, and he did. So, the rule on that is the name and the address of a victim while the assailant is still at large is not a public record. There the courts are saying, basically, you as a reporter have to be your brother's and sister's keeper to some degree. You cannot put them at risk of, and we're talking about a foreseeable risk of physical harm.